welcome to Subject to Interpretation. I'm your host, Maria Ceballos-Wallis. Today we'll be speaking with Janis Palma, a highly respected figure in the field of judiciary interpreting, with over 4 decades of experience as a federally certified English-Spanish judiciary interpreter. Janis has seen the evolution of our profession and the ethical frameworks that govern it. Janis holds a Master in Legal Studies from Arizona State University, along with a Master of Arts in Literature and History from the Centro de Estudios Avanzados de Puerto Rico y el Caribe. Her career spans conference interpreting, seminar work for the U.S. State Department, and consulting for various educational and government institutions. After a long tenure as a staff interpreter for the U.S. District Courts in Puerto Rico, she now resides in San Antonio, Texas, where she enjoys being a grandmother and giving back to the community. Today, Janis will share her insights on the history of the Legal Code of Ethics for interpreters. She will discuss its current relevance and the future implications for our profession. We're excited to have you here today, Janis. Welcome to Subject to Interpretation.
Thank you so much, Maria. This is going to be a lot of fun because I think I'm one of the few people who are still around and remember what happened at the very beginning of the profession. So it's going to be fun.
You're absolutely right, Janis, because not a lot of people know about this, and this is such an important topic which affects the work that we do on a daily basis as interpreters. Now, in your recent Najit blog, this was published on August 13th of 2024, you note the lack of documentation on the early codes of interpreting for judiciary interpreters. So based on your research and your personal experiences, what key milestones have shaped the evolution of the ethics in judiciary interpreting, particularly with the passage of the Court Interpreters Act of 1978?
The Court Interpreters Act was the first impulse for the profession to start to take shape and evolve. It's important to know where the Court Interpreters Act comes from, first of all, which is the U.S. ex rel Negron case, where this Puerto Rican 22-year-old is charged with murder. He is not given an interpreter for his trial. He's found guilty. And during the time that he's serving his sentence, he's trying to appeal his case. And finally, after a lot of courts said, no, 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 there was a judge in the Eastern District of New York who said, I want to listen to what this person has to say. And he found that it was totally unconstitutional to have somebody tried, especially for murder, and not be provided with an interpreter if the person cannot understand and speak English. And by the way, his attorney did not speak Spanish. And the only times when Negron knew what was going on was because an interpreter working for the prosecution gave him a little summary, so he kind of knew what was going on, and that was it. The government appeals, or the state appeals, and it goes to the First Circuit, I believe, and that was the case, the opinion from both the district court and the Court of Appeals that turned the tide. And then Congress was all up in arms because how can it be that you have people going to court charged with a crime and there's no constitutional protection? It is because of that that the Court Interpreters Act is created. So interpreters are created first and foremost to assist the non-English speaker, so they have the protection of the 5th, the 6th, and the 14th Amendments. Basically, due process, right? When the Court Interpreters Act is created, then they have to figure out, okay, how are we going to implement this? What are we going to do with these interpreters that have never been trained? They've never had any kind of contact with the courts to be told, this is what we expect, this is what we want, this is what we don't want. And so the test was created to certify interpreters. And with the test, there had to be a code of ethics. But in the meantime, interpreters were getting organized as well. And they organized in a few different associations. Some were regional or state associations. And one of them was called the Court Interpreters and Translators Association, or CITA. And it was a play and with the word CITA as a cite from a legal case. The association mostly had the model of conference interpreters. There was nothing else to look at. It was conference interpreters. What do conference interpreters do? What code of ethics do they have? And I believe that by that time, ATA had already been formed, but ATA was focused on translators, essentially. They weren't thinking about interpreters just yet. So these interpreters get together, and what they create is a code of ethical practices, which is kind of like an oxymoron, because ethics is one thing and practice is another, but they called it ethical practices. And okay, so the most important practice in their mind was, we have to work together. We have to, not only do a good job, but we need to be good colleagues as well. And so there's a lot of things in there that have to do with how interpreters work with each other, which I found really interesting. A lot of things that we don't see nowadays in those codes. But the very first sentence says that their duty is to interpret and to translate with the greatest fidelity and accuracy he or she can command, endeavoring at all times to communicate the impression of the original. And that was it. Okay. So yes, they understand that they have to be faithful to what they're hearing, right? You can't make it up as you go, basically. But this was the very first impression of a code of ethics. This is from 1981. And I know for a fact that this code evolved and had other versions. It was amended, but that's what I've not been able to find. Those amendments, those changes. I only have this one. I just happen to have this one from something I kept from 1981. And as you can imagine, since 1981 till now, it's been going all around the world with me as I move around. So I'm very fortunate to have that. On the other hand, as the Court Interpreters Act and the federal certification became more widespread and judges became more aware of the law, then the administrative office created a work group with those who had become certified and were hired now as staff interpreters. And that work group was also working on a code of ethics for interpreters with the administrative office. And I believe it was the Court Interpreters Advisory Group is what it was called. It may still exist in name, but I don't know that the group has gotten together recently to do anything. And they were working, and I remember at the time, one of the people I remember being in that group was Dina Millman. At the time, her name was Dina Cohn. So, and Dina was almost like the name of Dynamo. She got so many things done for interpreters. She was a great advocate. And so they tried really, really hard to have this code in as part of the handbook for judges and all the federal employees in the judicial branch, which now is volume 5. We know it as volume 5, but at the time they were going to call it chapter 5. And chapter 5 was going to have the court interpreter ethics and protocol. It did not get published until much later, but back in 1990, the concept of the interpreter from the court's perspective, from the federal court's perspective, state courts are still not in the game back then. Well, not at this level, let's put it that way. So, because some courts were starting to look at having their interpreters and having training and taking care of that part of the system of justice. So the Canon 1 in this code that was being worked on by the staff interpreters in federal court says, official court interpreters act strictly in the interest of the court they serve. So that already gives you the framework, the frame of mind of where this code is going. It is a set of rules that are coming from the institution of the judiciary to the interpreters as one of the many parts in this machinery that is the administration of justice. But it is not coming from the interpreters like the one that Sita created. This was just the interpreters getting together and thinking, okay, we need something that directs interpreters so they act ethically, and they put that together. This is being put together to serve the interests of the court. But
Janice,
still,
Janice, before you continue, maybe you could clarify for me. Is it possible to serve the interest of the court and to serve due process at the same time?
well, that is what, if the interest of the court is due process, then yes, and there is something here about due process. It would be Canon 8. It's down to Canon 8, and there's like, I don't know, like 15 canons back then. I'm talking 1990. So, figure out how long ago that was. But yes, there was an interest in due process and a closer awareness of the source of the Court Interpreters Act, which was due process for the non-English speakers. And the reason for interpreters to exist in the system, in the administration of justice, was due process for the limited English proficient, as we call them now. Back then, they were called non-English speakers. So Canon 8 says the official court interpreters fulfill a special duty to interpret, no, this is not the one about due process, but anyway, to interpret accurately and faithfully without indicating any personal bias, avoiding even the appearance of partiality. Okay. What this tells me is that there was still at the time an inclination, a tendency among interpreters in court who may not have been trained, or maybe were not certified, maybe they were in other languages, the tendency to favor the non-English speaker in some way, or to try to help them, or want to help them, or even offer legal advice. At that time, that is something that still, I believe, existed in some court environments. So that canon is addressing that issue. And then the one that addresses due process is Canon 11. Official court interpreters shall perform to the best of their ability to assist the court in providing due process for the parties. Due process disappears from the codes. It is never mentioned again after 1990. And I don't have an explanation for that, but eventually the focus shifted from the reason why interpreters were now certified. Interpreters now have a law specifically about court interpreting in the federal system. And I don't know if it was the passage of time. Time makes you forget. I don't know if it was because of court opinions that were kind of bypassing the appointment of interpreters. And that's another subject to discuss. But for some reason, due process disappears. Nobody talks about due process anymore. And then we have the model guide, the model standards that then were promulgated by the National Center for State Courts in 1995.
Now, Janice, before we continue talking about, I guess, the lineage of court interpreting ethical codes, could you tell us a little bit more of your understanding of the role of the interpreter in due process?
I understand that without due process, there is no room for an interpreter in a courtroom, because the only reason the interpreter is there is to ensure that the limited English proficient can have the same access as the English speaker. Having the same access means that you can hear everything that is being said, but it has to make sense to you. And it's a responsibility that is vested on the interpreter to transfer meaning from the English speakers to the non-English speaker or the limited English proficient so that things make sense. And I think it's always been that way. The intention has always been that the limited English proficient has this right to hear and understand everything that is happening. And all the court opinions are always about understanding what is happening in the courtroom, being able to communicate with defense counsel and that kind of thing. But it has evolved and maybe devolved into something that I find to be quite contrary to due process, because interpreters have been taught not to convey meaning in a sense that is understandable for the LEP. They've been taught to just simply repeat and even keep up with whatever speed the lawyers and the judges are speaking at, because you have to include everything in there. And maybe for the English speaker, it is understandable. We as English speakers are understanding what we hear. But when you turn that into the same message following this mandate of not being able to omit anything, then it becomes nonsensical. It becomes something that it's impossible for the LEP to understand because the interpreter is speaking so fast. And I know this is something that needs to be perhaps studied a little more in terms of comparing the understanding of the English speaker with the non-English speaker, studies that have not been done. And everything right now, as a matter of fact, that mandates interpreters' performance is based on speculation. It is not based on any research that shows that if you interpret this way, the non-English speaker is going to understand the same thing that the English speaker does. And so we are basing a practice on pure speculation of what it is that the interpreter needs to do to make sure that the non-English speaker has the same due process protections as the English speaker. Does that make sense?
Yeah, it makes complete sense. But I think that there would be some parties that would say that the interpretation has to be just such so that the non-English speaking party has the same experience as the English speaking party, regardless of their level of understanding.
But there's nothing about that anywhere in the law or the case law. There's nothing about having the same experience. And, in fact, there is an opinion from the Supreme Court that I don't have in front of me right now, but that explains that equal access, it's not something that is applied without taking into account the individual circumstances of each person. It's like, during sentencing, for example, and this with the sentencing guidelines now, the judges have to take into account the specific circumstances of every defendant in front of them. They can't just apply, okay, so it's this crime and it's this punishment, end of story. No, there are circumstances that the judges take into account in order to be fair. But for interpreters, the fairness factor has been eliminated from the equation altogether.
You were going to tell us more about the National Center for State Courts Code of Ethics. Did that Code of Ethics continue on the same path of, I guess, obviating the concept of understanding in the due process, or where did it go?
The National Center for State Courts creates a code that I think they were trying to take into account the due process because they mentioned it at some point, but then, and the canon that concerns me the most, that has always bothered me, is the one about accuracy, and that's the one in which I'm going to be emphasizing my analysis of the different codes, because I think that's the crux of the matter. That's where we have a real problem. So the National Center puts out a canon on accuracy and completeness that mandates, because it's what is known as a deontological code of ethics. It's a mandate. It's something that you have to do. You have no choice in the matter. You have no say in the matter. You have to. So interpreters shall render a complete and accurate interpretation or side translation without altering, omitting, or adding anything to what is stated or written, and without explanation. Where does this go? This goes to the interpreter who is not trained. It goes to the interpreter who doesn't know that they can't put in their own words, who doesn't know that you can't leave out whatever you think is not important. It's the kind of mandate that is not taking into account what a trained, competent, qualified interpreter can do when they apply their critical thinking skills. There's no room here for an interpreter to have any critical thinking at all. And it has caused confusion because it does not define what altering means, or what omitting and adding means. Does not take into account what we know in linguistics to be necessary strategies in order to convey meaning accurately. You don't, and we know that we don't do word for word, but still, when interpreters see this, they think, oh my God, I have to say every word. I have to translate every word. I can't leave anything out. And it has led to misunderstandings about accuracy. And it has also left out other languages, like we were talking the other day about indigenous languages. This does not take into account languages from other cultures that you have to make all these movements, linguistic movements, in order to convey meaning, and you cannot be tied to the source language. So this is a code that is tied to the source language and constrains the interpreter's ability to make intelligent decisions about the way in which the target language message is going to be conveyed. And in that sense, I think it's undervaluing the interpreter. But then again, we're talking 1995. So we're still at a stage in the development of education and training for interpreters that it hasn't evolved much. It hasn't advanced much by 1995. So we still have, and this is for state courts, so we still have a lot of people claiming to be interpreters, and maybe they're just like the bailiff's brother who happens to be bilingual, and they just said, oh, sure, bring him in. Yeah, he can be the interpreter, or the niece of the courtroom clerk. Yeah, bring her over. She can be an interpreter, of course. Yeah. And there's no quality control. There's nothing to assure that this person knows what they're going to do. And so they use a code of ethics that is essentially a straitjacket for interpreters.
So Janice, we've covered the CETA code, and we've covered the CIAG code, and started talking about the National Center for State Courts code. But there seem to be a whole lot of other ones out there over the years that either were created separately or that were, I guess, that evolved from existing codes of ethics. Which other ones have played an impact in how we see the role of the interpreter?
I think the National Center for State Courts has been the most impactful because they packaged the code with the certification exams, the consortium exams, and they prepared a very nice package deal for the states to adopt model laws to implement certification for interpreters, model certification exams, and model codes of ethics. So it's like, here, we did it all for you. You don't have to do anything. Just pick it up, copy paste, whatever. So most states, if you read their codes, are going to be exactly the same language as the model code that the National Center put out. But some have changed a little bit here and there. Some have evolved. Like New Mexico right now, I think has a really good code that totally stepped away from the one from the National Center for State Courts. And then there's all the ones that have just distorted the whole purpose of having an interpreter. So it's not going to be exactly the same, but most of them are modeled after this National Center 1995 code, and they have not looked at it again. It's like we copied, we pasted, that's good enough for us. Other codes have revised. But curiously though, the Federal Code of Ethics for Interpreters, the last revision that I found was 2014, and it has adopted the National Center for State Court Language. It's amazing. I mean, okay, the National Center says interpreters shall render a complete and accurate interpretation or side translation. The federal one, interpreters shall render a complete and accurate interpretation or side translation. And then it goes on. They do add that preserves the level of language, but then it goes to without altering, omitting, or adding anything. And hence the failure of these codes is they put in words they do not define. Usually, when you create anything that is going to be regulatory or mandatory, you define the terms that you use so everybody understands what you mean when you use these terms. And these codes, like I said, they are mandatory, they're deontological, they don't give you a choice whether, if the consequence is that somebody's not going to understand anything, well, it doesn't matter. That's the code. There are other ways of approaching ethics. Ethics is a philosophy that dates back to the Greeks, and there's something called teleological ethics. And teleological ethics focus on the consequences of your actions, not the rules. They're not rules. They provide guidance, because if you do this, this is going to be the consequence. If you want a good consequence, then this is what you do. And that's a different type. It's what I think the association, what is it? Interpreters and Translators in Education. Okay, AITE. They when they wrote their code, they call it descriptive. But what they call descriptive is more like the teleological, where you think about the consequence of what you do, rather than the deontological. And I think they call it normative, which is the one that doesn't let you consider any option. You just have to follow the rules blindly. And that's what interpreters have been doing. They've been following the rules blindly without questioning, without thinking, hey, somebody wrote this 20, 30 years ago. Does this still apply? Is this still pertinent? Is this aligned with the way things are today? And what we have, one of the horrible things that I have found is the Interpreters Code in Iowa. It shows two things. Okay, it says the same thing: an interpreter must render complete and accurate interpretation or side translation. Same thing as a model code. But then in the comments, it says the interpreter should express the style or register of speech, the ambiguities and nuances of the speaker, and the level of language that best conveys the original meaning of the source language, even if the LEP participant does not completely understand that level of language. So this is an absolute contradiction with the case law and with the reason why the Court Interpreters Act was created, the reason why the federal certification was created, the reason why interpreters are in court. But then we have the other consideration is that when these rules were written, I don't think they were thinking about simultaneous interpreting. I think they were only thinking about testimony and how to convey testimony accurately. And for that, it makes sense that it doesn't matter if the LEP on the witness stand can understand the question as it is on the record, because that is the record of the court. And so if the witness cannot understand the question, that should also be reflected on the record. And the witness will either answer or say, I don't understand. But when you're doing simultaneous for an LEP, they're not going to stop and say, I don't understand, especially nowadays when we have electronic equipment in almost every courtroom. The interpreter is not even close to the LEP defendant. How is that defendant going to tell the interpreter, I don't understand, so that the interpreter can then tell the defense attorney, and then the defense attorney is going to do what? Because maybe it's not the defense attorney who's speaking, maybe it's the judge, or maybe it's the prosecutor, the other attorney. I mean, the logistics of what is expected of interpreters at this point, what is expected of the LEP at this point with these rules are completely illogical, because they don't fit the way things are done right now. When the interpreter was sitting next to the LEP defendant, which is the way that we worked at the very beginning, there was no equipment, maybe he could turn around and say, oh, I don't understand that. Can you explain that to me? And then you turn to the lawyer and you tell the lawyer, But nowadays with equipment, how is that person going to say, wait a minute, I don't understand. What was that? What did you say? What, can you explain that to me? Really? Is that a realistic expectation? I honestly don't think so.
Well, it's also a very intimidating environment for pretty much anybody who's in a courtroom, maybe not so much for the attorneys, but certainly for the limited English proficient defendants. And so at that point, it's complicated as to how you're going to react and how much attention you're going to draw to yourself, unless maybe you're being asked a question specifically, as you said. And I think it's a really, really key that you are distinguishing between the intent for the consecutive mode and I don't even think there's an intent for the simultaneous mode. Maybe it's just they just didn't consider it, maybe.
I don't think they did. Now, let me read to you the one from New Mexico, because this is where we see that they're starting to think these things through and not just perpetuating something that was written decades ago and is no longer relevant. Standard 1. Interpreters interpret faithfully and accurately. That's the title. Interpreters recognize that their function is to facilitate language access between two or more participants in the justice system who do not speak the same native language. Interpreters do everything possible to remove the linguistic barrier between the judiciary and the persons whose first or primary language is not English. Now, isn't that so much better than saying you do not add, you do not omit, you do not? I think this is much closer to the reality of the interpreter nowadays.
Well, Janis, I also think it's actually very refreshing in the sense that you are actually, I always say this to people, I'm not just the interpreter for the defendant, I'm also the interpreter for the court. I'm the interpreter for everybody who is in that courtroom, in that proceeding, who needs to communicate with each other. And that acknowledges that this is not just a service being provided. So, let's just say, to a second-class citizen or a person who, does not have the skills to keep up. This is I don't want to say service, but this is a process which is in place to ensure that everybody who is part of the conversation is able to be an active part of that conversation.
Exactly. It's a two-way street. But it has been, because of these codes, I should say, this one code that then multiplied, over and over. It became a one-way street. It became a way of limiting the interpreter's ability to expand their knowledge, actually, because all the interpreters, if you think about it, the only thing that interpreters were taught and possibly still are is, okay, this is how you do the consecutive. This is how you do the simultaneous. This is how you do side translation. This is the terminology. If you want to take notes, you can use that as an aid. End of story. Beyond that, beyond the mechanical aspects of interpreting and the legal terminology that is always being debated, that's all interpreters are taught. They're not taught anything about the way language works, about grammatical structure, and how you can play with grammatical structures in order to make a sentence more accessible to the listener. They're not taught about semantics and how a word can have many different ways of being conveyed, and you're still being faithful, but you're just giving a semantic equivalent rather than, the very first word that the dictionary gave you. They're not taught about pragmatics, which is a way of understanding meaning that goes far beyond just the words. It takes into account, well, if somebody is asked, where do you live? And they say, excuse me, I don't know the address. I know how to get there. Then there is a pragmatic aspect to that. It's linked to a culture. It's linked to a way of seeing and understanding the world that is different from the way of seeing and understanding the world in the United States. And the way that the interpreter approaches that, and that may not be a good example, but there are other examples in which the interpreter can approach things in maybe using intonation, or maybe even using facial expressions. When I have something from the Spanish speaker, Spanish being my language, that I know is not going to make sense to the English speaker because of cultural factors, I will look at the English speaker like saying, this is exactly what this person said. Listen to what I'm saying that this person said, so you can look behind the words and understand there's something here that's not matching your world, And I try to say all of that, which is my face, because otherwise I may be looking at my paper notes and whatever, but there is an intentionality, and that goes into English as well as into Spanish, to make sure that if there is something that can cause miscommunication, at least they will pick up on it, because that's all I can do. But other things that I do to facilitate communication in simultaneous and consecutive, depending on where I'm standing and whether I have a line of sight with the defendant, is I will use all the nonverbal elements of discourse that we normally use when we speak to convey meaning. That is part of meaning. And interpreters, because they've been told not to emulate gestures, they're so scared of using the natural nonverbal language that you would use communicating in your native language. And there's such great deficiency in the way interpreters are educated and trained, that of course they are still wearing that straitjacket, because nobody has come to them and told them, hey, you have these ways of communicating meaning accurately that don't really limit your choices. And it doesn't mean that you're going to do this thing that I hate this term, dumb down the language, because that is so demeaning of the LEP. So I would ask everybody who's listening, please do not use that phrase of dumbing down the language, because they're not dumb. They are in a very alien environment, with people who speak a language they don't speak, facing consequences for something they did that may be more or less serious. They're not dumb. They just need to understand, and the only person who can provide that understanding is you. And you don't have to change what they call register, which is again another term that has been misdefined, but you don't have to change the style. You can change maybe the grammatical construction of the sentence, or maybe there are two different adjectives that you can use that are equally valid, but one is more commonly used in your target language than the other, so it's going to be easier for the person to understand than if you use another adjective that is not as common. All these things are available to us as interpreters to do our job, to protect the due process rights of the limited English speakers.
So Janice, I'm so glad you brought this up. And you know, there's always this question, are interpreters linguists? And so this is my take on it. Some linguists are interpreters, but not all interpreters are linguists. And that's precisely what you've been talking about. And it's very important. And I think it's actually very pertinent to the conversation, the larger conversation we're having about ethics, in the sense that when you take away the interpreter's ability to act with critical thinking and to and to also be that conduit, that cultural conduit, that linguistic conduit, then you are essentially, you're, you know, the next closest thing is, you know, maybe, you know, artificial intelligence. I don't know.
That's exactly right. Artificial intelligence has no latitude to make adjustments. And like I said, it's very sad that interpreters are not provided more information, training, education that goes beyond the 3 basic skills and the legal terminology. And I would like to encourage anybody listening to this podcast to not wait for somebody to offer a course. There's a lot of things that I learned just because I wanted to read something that I thought had something to do with interpreting. It could help me be a better interpreter. Or more recently, watching YouTube videos that have helped me understand what semantics are a little better, what pragmatics are. And that's without being a linguist. A linguist knows a lot more about all of that. And interpreters barely know about grammar and syntax. And that's not enough. That's not enough to be an interpreter. An interpreter should know more about language and communication than just, hey, this is the grammatical structure in my target language, and these are the terms in my glossary that I memorize, and that's it. That's not being a linguist.
Over the years, we have had all of these codes of ethics, as you have explained, and we have had variations on a theme, so to speak. What role have interpreters played in the creation of these codes of ethics that essentially govern the activities that interpreters are meant to fulfill?
Well, what I think is that there have been interpreters involved in these committees or commissions or whatever you want to call them, but those interpreters have not been there to serve the interests of the profession of interpreting. They have been there to serve the interests of the institution that is creating these codes. So with the advisory group, they're serving the interests of the federal judiciary. With the model code from the National Center, they were serving the interests of the National Center. So interpreters creating a code for interpreters in the interest of the profession, I think is a more recent phenomenon, and it is not happening in judiciary interpreting. Except for this one that I just read from New Mexico. I am assuming that interpreters had a lot to do with that one. I haven't seen any other.
What about the Code of Ethics created by the National Association of Judiciary Interpreters, which incidentally used to be CETA, correct?
Yes. So interesting. I have not been able to find the earlier codes, and I was there, and I know there is an earlier code. I just have not been able to find it. If anybody listening knows of an earlier NAJIT code, please send it my way or send it to Maria. But I'm going to tell you something really interesting. The NAJIT code has the exact same wording as the code for Rhode Island, and it's different from all the others. So I don't know who was there from Rhode Island when they wrote this, but it is exactly the same wording. Source language speech should be faithfully rendered into the target language by conserving all the elements of the original message while accommodating the syntactic and semantic patterns of the target language. That tells me somebody is writing this who knows more about interpreting than just do not omit, do not add. And then they say the rendition should sound natural in the target language, and there should be no distortion of the original message through additions or omissions, explanations, or paraphrasing. So boom, there it is again. And then here's where I know that this is written with the consecutive in mind, because it goes on, and this is one of the longest canons of accuracy on any of the codes. It goes on to specify all hedges, false starts, and repetitions should be conveyed. Also, English words mixed into the other language should be retained, as should culturally bound terms which have no direct equivalent in English or which may have more than one meaning. At which point in a legal process is this important? On the witness stand. And English words mixed in with the other language, what are we talking about? We're talking about the LEP going into English, mixing English words, and all those have to be conveyed fully. This is, to me, it's an X-ray of what the consecutive should be, and the standards for consecutive interpreting. But for simultaneous, what possible importance do hedges, false starts, and repetitions have in a simultaneous? None. They have, I mean, again, there's no study that can show what the LEP is understanding versus the English speaker. But just thinking about the way we normally engage in conversation, when somebody starts to be too repetitious, we kind of tune it out. When people start to go, the thing is, you tune it out. You're not focusing on every single hedge and every single repetition. That's not how we communicate. That's not how we process language. So why are we asking interpreters to do that for the LEP? It makes no sense. It's just so disconnected from communication theory and language theory. And it's something that needs to be reassessed based on what happens in the simultaneous versus what happens in the consecutive.
Now, are we missing any codes of ethics that you wanted to talk about before we talk about the implications of all of this mishmash?
I don't have any more. I think that was a good cross section.
Yeah, I mean, we could always go state by state, but we're going to find a lot of overlap between them, right?
Absolutely, yes.
So, Janis, judiciary interpreters often work across both state and federal courts. And as you have very eloquently stated, each have its own set of ethical standards, and even from state to state. Now, what challenges do interpreters face, maybe from your own perspective, when navigating these different codes? And do you believe that there should be a unified national standard to bring consistency across jurisdictions?
I think they become terrified that they're going to do something wrong because some of these codes actually impose sanctions for violations of the code. So when they move from one state to another, I think they're mostly paralyzed, frozen by fear of doing something wrong. So they tend to go the literal route. They tend to stick to the source language rather than think in terms of the target language and how things make sense in the target language. And that's really sad because again, it's going against the whole purpose of having an interpreter for an LEP defendant or a litigant. I mean, they all have the same right to understand what is going on. Not just the words, the individual words, but the message, the meaning, the overall thing that is happening there for them. And to create a unified code, and I'm all for it, we need to improve the way that interpreters are trained and educated. And I'm speaking about training by small groups or individual instructors, and education in universities or other institutions. And we also need to set some uniform standards for the performance of the judiciary interpreter that are going to inform a code of ethics for everybody across the board. What does it mean? What does it mean to be accurate? That is a performance standard that nobody has defined. You're not defining it by saying you do not add or omit. That does not define accuracy, because there are no two languages that are mirror images. So you're always going to have to add or omit, always. So what does that mean? We need to define those things. We need to have clear standards that are clearly defined, and then we can have a uniform code of ethics, and then we can have good programs that really prepare interpreters to excel when they go in the court, to use knowledge and their good judgment and their best judgment and their critical thinking to make sure that those people who do not speak the language of the court have their due process rights fully protected.
Let's talk about what you called an oxymoron earlier, which is the code of ethics. I can't remember how you actually phrased it.
It was like ethical performance, I think.
Exactly. So one thing, ethics is one thing. Ethics is based on values, mores, accepted by a society, uniformly accepted by its, population. And practice and standards of practice are how we're going to actually bring those about, how we're going to execute those, let's say. Talk to me about how those two things have become so intertwined that they're practically indistinguishable, and how maybe that might be one place to start.
Every example that I have given you that is supposed to be a code of ethics is actually talking about practice. It's saying, this is how you do, and it's not saying interpreting as a profession upholds the value of professional development, let's say. Professional development, but knowledge growth, building up your skills continuously. That would be a value. But then the way that you implement that value is by going to courses and this and that. So that's the difference. The value is constant improvement, or something like that, of your knowledge and your skills. And then the practical aspect of it is either reading or taking courses or watching movies or whatever. That would be the practical aspect of it. Another value would be perhaps impartiality. Interpreters uphold the value of impartiality So their renditions are never tainted by bias. How do you do that? Well, when you go to interpret, you make sure, for one thing, you don't engage in chit chat with the prosecutor or the defense attorney or anybody else, the defendant, the family. That's one way in which you implement the impartiality principle. You make sure that your choices in your target language are always going to be the best and most appropriate, regardless of the circumstances, regardless of who you're interpreting for. So right now, all of that is mixed up in the codes of ethics. And they tell you, okay, this is the code says, let me see if I can find one. Here's one. Impartiality, precisely. This is from the orientation manual of the federal court interpreters. Says, impartiality. Interpreters shall be impartial and unbiased and shall refrain from conduct that may give an appearance of bias. During the course of the proceeding, say paragraph, then it tells you, during the course of the proceeding, interpreters shall not converse with parties, witnesses. That's practice. That's not ethics. That's not an ethical principle. That's a practical application of the ethical principle. And it happens in every single one of these principles.
Let me ask you a question, Janis. Can there be such a thing as practical ethics?
No, ethics is a philosophical concept. It's something that has to do with values. It's not a practical thing. It guides the practice. It guides your conduct, but it's not a practice per se. It is a value. It is a set of values, whether it's one or several, that guide your behavior and the behavior of a community, so that everybody agrees this is good and this is bad. And one society can agree that one thing is good and another one can agree that's not good, that's bad. It doesn't, there is no universal set of values for all humanity, but for every profession, there should be a set of values. And I believe that there can be a set of values that is applicable to interpreters across the board, regardless of the domain in which they practice. I do believe that is possible.
Now, is it even possible, though, for the code of ethics for interpreters in general to be multidisciplinary, that is to encompass all sectors of interpretation as we know it today: medical interpretation, educational interpreter, judiciary interpreting, public service, community, etc.? Or should each, I guess, discipline adopt a code that suits each sector with the requirements and with the practical considerations that need to be applied in each area?
If we keep ethics to a set of values, I think all interpreters in all domains will share certain values that, like I mentioned, like impartiality and the professional development. Accuracy, of course, has to be redefined as a value and not as a practice. Confidentiality is another value. We need to really take a good look at what has been fed to us as a code of ethics, and take a look and see what is really ethics and what is something else. And then once you have the common ethical values for all interpreters, then you can start to branch out and then have a code of professional practice. And in this domain, this is your code of practice. And in this domain, this is your code of practice. And then they can make the necessary modifications for that code of practice to fit the reality of the interpreter within that specific domain. But the ethics don't need to change. The ethics, we're going to be we're going to maintain confidentiality no matter where we work, right? Whatever we hear is, strictly confidential. There's all the privileged communication. If interpreters understand the difference between confidentiality and privileged communication, they will know, okay, this is something that I cannot share with anyone, or this is something that the judge can order me to disclose, and I have to disclose. So the problem that we've had with the codes of ethics and the fear that interpreters feel when they go from one jurisdiction to another, or from one domain to another, that they may be doing something wrong, is because they're not clear. They have not been clearly defined. And I'm not talking about the recent ones, because I think recent codes have had a lot more thought put into them about all these issues. But in the judiciary, we are still, the most recent one, 2014. That's the most recent revision of any code of ethics for judiciary interpreters.
And
This
Janice,
is 2014. Yes.
Janice, 2014, and regardless, over 2014, 2024, so we're talking at least 10 years, but even over the past 30 years, as you mentioned, judiciary interpreting has evolved considerably. So what would be some of the biggest changes that you've observed in the profession, and how do you think these changes should be reflected in a current model for a code of ethics for judiciary interpreting?
First of all, we have to move away from a code of professional practice that's only for consecutive interpreting from the witness stand. That's the first thing. I mean, there's consecutive interpreting in other environments, like we have a proffer session, for example, a plea negotiation, an attorney-client interview, a probation pretrial interview with a defendant. There's so many other exchanges in which the consecutive mode is used. An arrest is going to be something different from the final interview before sentencing that the pretrial officer conducts, and it's going to be different from the attorney speaking to the client. Jail interviews, for example, are so different from an interview in the attorney's office. The environment is different. There are circumstances that are not being taken into account, and they should be taken into account. And then there's the simultaneous that happens in a trial versus the simultaneous during a change of plea or a sentencing hearing or an arraignment or an initial. Those are all different simultaneous scenarios. None of that is being considered right now in any of these codes. Never mind that it's the ethics and the practice all mixed up. Even the practice is not considering that we're doing different things. And then they're not considering what happens when you're sitting, I don't know, distance. I don't know how to measure distance, but you're far away from the person for whom you're interpreting, because you have a headset and a microphone, and the person has a headset and they're listening to you, or maybe there's a whole bunch of people listening to you at the same time. None of those scenarios are considered. What happens when the judge starts to go down the line? And what's your name? And the person answers, and the judge doesn't even wait for the person to finish before they're already asking the next person. They're not listening to the answer, but you have to say the answer. And you're like, tripping over your own tongue. And how about having team interpreting for that? Even if it's not a trial or a hearing, even if it's not even a long proceeding, but if it's going to be complicated like that, where a single interpreter is going to be tripping over her tongue in order to do things right for the record and for the defendants and for the judge and for everybody, let's consider what our reality is nowadays and incorporate that into a code of professional practice.
In addition to all of these scenarios you've mentioned, we haven't even touched upon the fact that these codes of ethics and the code of professional practice were, I guess, really designed for languages that were let's say, major diffusion, or languages that dominant languages, let's say. Here at Subject to Interpretation, we've been trying to, bring in a whole bunch of different, topics, which in the end up converging one with the other. And we recently did an interview with Odilia Romero, representing indigenous Latin American communities. And that in itself presents a lot of different challenges, especially when the codes of ethics and when the standards of practice are only consider, dominant languages in communities that have extremely high diffusion.
Well, this is where I think that part of the deficiency has to do with the lack of consideration of other factors in the interpreting process, like pragmatics. The difficulty, and actually, I don't think that any other language was considered, maybe Italian, maybe, I don't know, Portuguese, but when these codes were developed, I don't think there was much thought given to other languages except Spanish. And the fact is that with any language, you need to take into account the cultural differences, because language and culture cannot be separated. And even for Spanish, which is the language that is spoken the most in the United States among, all the languages other than English, there is still this misconception that if you interpret Spanish, it's going to be so much easier. You don't need to make too many adjustments because it's close to English. I don't think so. It's not. It really isn't. Why are we thinking that we don't need to make adjustments for cultural differences? And that becomes very clear when you are talking about an indigenous language. Oh, yes. Oh, for the indigenous languages, yes. They can't do it like the Spanish interpreters do it. For Punjabi, oh, yes, no, the Punjabi interpreter cannot do the same thing. Yeah, they can paraphrase. They can explain. They can use other equivalents that may not be the exact equivalent, but the Spanish interpreter cannot. Even if there are 20 different legal systems in Spanish-speaking countries and there are no real legal equivalents, oh no. The Spanish interpreter has to use a legal equivalent from one of those 20 countries. And if not, well, let's make one up. Instead of paraphrasing, which is the logical thing to do to convey meaning. And I know that you spoke with Odilia about this, and I really felt her pain as I was hearing her, because again, interpreters have been put in a straitjacket, and what happens is that they're not doing the job that they were supposed to do. It's a disservice to the LEP. It's a disservice to the community that has a right to be present, to understand, to be able to defend themselves like everybody else. It's, I'm sorry, but it's something at some point along the way, things got really distorted. And we are at a point right now where we shouldn't be, because this is not what interpreters were created for. This is not why this profession was created.
So, Janis, looking ahead, what steps would you envision for developing a new, updated, maybe, code of ethics for interpreters that is more faithful to the original intent and the purpose for the existence of interpreters, followed then by a code of professional practice that reflects the current realities that we are facing with so many different aspects, Zoom court, AI, remote interpreting equipment, or wireless interpreting equipment, team interpreting, all of these different modalities, simultaneous and consecutive, and also sight translation, because we haven't talked about that, but sight translation also has its own, there's lots of things that we don't generally talk about with sight translation. We end up having to educate people. No, we can't sight translate these 5 pages in open court, especially not if there has already been another official translation submitted for the record. So we don't need to get into that, but all of those things are just so critical, and they're not accounted for.
I don't know where to start. I don't know where that would start, but now that you mentioned sight translation, there is something that I keep hearing about interpreters and translators being so different. And the fact is that if you're an interpreter, doing translations is one of the best ways to improve your skills, to get your mind to work fast, to find solutions fast. That is a great resource to get your mind moving a little faster when you have to go from one language to another. And we don't pay as much attention to sight translation because it's like something that if you can interpret, you can do it. Everybody thinks that. It's not true, though. But you're right that we don't give too much attention to that. Just and transcripts and translations too. That's another skill set. But I would not know where to begin. I know that it needs to be done. It's because we are falling so far away from the original intent of having interpreters in the court, which is what happened to Negron, which was not being able to understand what was happening in a criminal proceeding against him, where his life and his liberty were at stake, to where we are now, to where the court say it doesn't matter if the LEP understands. How did we get here? How did we end up and where interpreters say, I don't care if they understand me. That's not my job. Well, then what is your job? And they said, well, my job is just to interpret, to repeat basically what I hear in English. Okay, well, how does that make you an interpreter that conveys understanding, that provides understanding to the limited English proficient? I don't know where to
Janis,
start.
who should be involved in this process? I mean, should interpreters be involved? Who should lead this task? Because before you answer, I'd like to point out that somehow, somewhere along the way, judiciary interpreting, which was a trendsetter, all of a sudden kind of got left by the wayside, and then medical interpreting came in, associations, and with new certification, now educational interpreting has taken up that mantle. And the association you mentioned earlier was the American Association of Interpreters and Translators in Education, AAITE. And they had a whole process on creating a code of ethics that they felt would suit their purposes. We did a podcast with Carola Lemacher, who is the chair of the Code of Ethics Committee. So for our viewers and our listeners, you'll get a chance to review that. So where are we? What are we doing?
Well, let me tell you, the beauty of interpreters in healthcare and now interpreters in education is that they never had the straitjacket that judiciary interpreters had, and we have not been able to get rid of it because they are free to develop their rules, their knowledge, their standards. They have been able to flourish, but judiciary interpreters have been curtailed. We have not been encouraged to grow as interpreters. We have been encouraged to just don't rock the boat, don't go there, don't ask questions. And so, how are you going to grow as a profession when every individual is fearful of questioning, of looking for new ways of doing things, of being accused of being unethical? Because if you challenge the status quo, if you challenge the dogma, you risk being labeled unethical. So they have been very fortunate, and I'm really happy for them that they had all this fresh field to plow with, seeds of knowledge and seeds of growth, and we're not even allowed to leave the barn, so to speak.
Well, Janice, you're not a stranger to controversy.
No.
You're not a stranger to rocking the boat. Is this a mantle you might take up?
I am certainly not afraid of rocking the boat, and sometimes I feel like, well, if I don't do it, who's going to do it, right? So somebody's got to do it, and it's one of the advantages of gray hairs, old age.
Hey, I don't admit to that.
You feel less vulnerable. You feel like the consequences are not going to be as severe as being, for example, blackballed, or something like that. So I have been trying for several years to get people together to at least talk about it. Let's talk about the code of ethics. This really needs revamping, and then it just like dissolves like a soap bubble. And I guess I'm not very good at getting people together to do things, but I'm not going to stop trying to get different people to think about it. At least think about it. At least consider the possibility that you're not going to be ostracized from the profession if you question something in the code of ethics. It's not a mortal sin to say, hey, I think we need to convey meaning in a different way so that it is understandable, rather than just repeat every word that we hear, whether or not it makes sense.
And in the upcoming ATA conference, you'll be speaking in a panel about the future of ethics, right?
I am. It's called The Future of Ethics, and it's a panel with different associations, which is kind of like the dream situation for a new code of ethics, is to get everybody involved. And I mean interpreters, because sometimes when they talk about stakeholders, they start to include people who are not interpreters, and I'm like, wait a minute, this is for interpreters, so why are you bringing people from the outside who are not interpreters? But anyway, that's just me. And the thing about that panel precisely is to highlight the things that we do have in common, and highlight the things that bring us together. And that's a movement that I'm seeing lately that I really like, which is different associations working together and finding common ground. And so moving towards goals that are beneficial for everybody and doing it together, like joining forces. And I really like that trend that I'm noticing. And of course, during the panel, like I said, we're going to be talking about what brings us together, what ties us together as interpreters, regardless of whether we're in healthcare or education or judiciary, or regardless of whether we're translators or interpreters, because some of the issues are also, well, I'm a translator, so this part does not apply to me. Well, if you're a translator, you have to be accurate. If you're a translator, you have to be neutral or impartial. If you're a translator, you have a duty of confidentiality. If you're a translator, you also have to be developing your knowledge, your skills. So all of these things are the same for everybody. It doesn't matter if you're an interpreter or a translator. We all start from the same common ground, we could say. And then, okay, the interpreter goes one way, the translator goes a different way, develop different skills. And then the interpreter, and probably the translator too, will branch into different specialties. Some want to do medical, some want to do education, some want to do legal. I can tell you that in my early years, I did some medical, and I don't like it. I would not. I have focused my whole life on developing my skills as a judiciary interpreter and my knowledge and vocabulary in my domain. But if I wanted to shift to another domain, I would have to put in the same level of intense studying and learning and developing skills for that domain. And that is the only thing that can differentiate interpreters in the different domains. You have to focus on the knowledge and the skills for that, for education or for healthcare or for judiciary or conference or, whatever.
Janis, thank you so much for joining us here on Subject to Interpretation. I wish we had more time, but we're going to have to leave it there. We hope you'll come back after your conference and when you begin a whole new project regarding the revamping of the Code of Ethics for judiciary interpreting.
Okay, we'll see what happens. Thank you for having me. It was fun. I said it was going to be fun. I hope everybody enjoyed it.
Well, we certainly hope that you enjoyed it. And Janis, really, your experience and dedication to the profession is truly inspiring. So thank you so much.
Thank you, Maria. Thank you.
As we wrap up this episode, let's reflect on the vital role that ethics plays in our work as interpreters. Understanding and adhering to these standards not only enhances our professional practice, but also strengthens the trust placed in us by those we serve. To our listeners, we hope you've enjoyed this insightful discussion. If you're interested in learning more about interpreter ethics and wish to connect with Janis, feel free to reach out via her email at palmajanis88@gmail.com. That's PALMAJANIS88@gmail.com. And don't forget to visit us at the De La Mora Institute of Interpretation at our website, delamorainstitute.com, for upcoming courses and resources. We'd love to hear your thoughts on today's episode and any suggestions for future topics. You can reach us at podcast@delamorainstitute.com. Thank you for joining us here on Subject to Interpretation. And as we like to say, never stop learning.